Good day, attorney and classmates. We are Group 7 and we will be presenting about the case of ACI Philippines Inc. versus Edita C. Coquia. On October 6, 1994, ACI Philippines entered into a contract with Edita C. Coquia for the purchase of one lot of flint collets consisting of 2,500 to 3,000 metric tons at a price of 4 pesos and 20 centavos per kilo under purchase order number 106211. To fulfill the obligation, several deliveries were made by Edita C. Coquia which were then accepted and paid by ACI Philippines Inc. at the unit price of 4 pesos and 20 centavos per kilo as agreed upon in purchase order number 106211. On October 28, 1994, ACI Philippines Inc. demanded to reduce the purchase price from 4 pesos and 20 centavos to 3 pesos and 65 centavos per kilo, to which Edita C. Coquia acceded, however, allegedly under duress. ACI Philippines Inc. then issued purchase order number 106373, explicitly replacing purchase order number 106211. Deliveries were accepted by ACI Philippines Inc., but they refused to pay for it and demanded for price to be further reduced at 3 pesos and 10 centavos per kilo. With that, Edita C. Coquia filed a complaint for specific performance and damages against ACI Philippines Inc., demanding payment for delivery receipt numbers 901, 719, and 735 amounting to 46,390 kilos at the negotiated price of 3 pesos and 65 centavos per kilo. 3 days after the filing of complaint, ACI Philippines Inc. paid for the flint collets under delivery receipt numbers 901, 719, and 735 at the unit price of 3 pesos and 65 centavos per kilo. On September 15, 2005, the Court of Appeals held that purchase order number 106211 is a contract of adhesion whose terms must be strictly construed against ACI Philippines Inc. With that, petitioner claims that the Court of Appeals erred in ruling that purchase order number 106211 is a contract of adhesion. Moreover, petitioner asserts that the appellate court erred in affirming the trial court's decision which compelled it to accept and pay for the deliveries at the price of 4 pesos and 20 centavos per kilo. Lastly, it also alleges that the appellate court erroneously applied Article 21 of the Civil Code despite the existence of the purchase orders, which should govern the contractual obligation of both parties.
Petitioner also claims that it did not intimidate the respondent, and even if it did, this voidable contract was ratified by the respondent after the delivery of the flint collets on October 28, November 16, 1994 with a price of 3.65 pesos per unit. So the Court of Appeals identified three issues in this case. First, whether petitioner can still accept the deliveries of washed collets from respondents. Second, determining the unit price applicable. And third, who is entitled to these damages. And these issues are in relation with the contracts of adhesion that the appellate court claimed against petitioner, in which it is later found that some of the conditions provided in the purchase order are actually more in favor with the respondent. It is therefore decided that the contracts of adhesion cannot be applied for this case. Note that the delivery date is the main essence of the contract because the petitioner only entered into the contract after the respondent assured that she could promptly deliver the object. With the testimony of its materials control manager and Ermelinda Batalon, it gave a clearer picture on the transactions that happened between both parties. And on the second purchase order, it stated the reduced unit price, but it did not state the quantity to be delivered.
For the outcome of the case, first, the purchase order number 106211 was novated by purchase order number 106373, wherein the original obligation was extinguished in order to not novate a new obligation granting the price that is in favor of the petitioner without any stated quantity, in other words, an open purchase order. Second, the petitioner cannot be compelled to accept more deliveries of plain collets from respondent to complete the quantity originally contracted for. On the new purchase order, there wasn't any statement of stipulated on the amount of flint collets that the respondent needed to deliver to the petitioner. Third, both of the parties weren't able to show any factual evidence of the damages that had been done. Both of them are lacking from any factual documentary evidences that will show the damages taken. Most of it are just purely personal testimonies on the side of the respondent, while on the petitioner doesn't have any document to show on the loan with certain interest that will be used for buying the flint collets. Lastly, the decision of the court, appeals, and resolution are reversed. Later on, they find the appellate court's citation of Article 21 of the Civil Code misplaced not only because of the pre-existing contractual relation between the parties which bars the application of this provision,